well. We wanted to.
Oh, I can bring it.
Well,
Yeah.
okay.
Okay. Oh, we're good. Sorry, just making sure all the things. Can you guys hear everyone online? Can hear okay? And we are very,
I'm sorry, I'm gonna bring all of this to you.
we are excited to have Kristy Pike with us, who is the director of the Washington County CJC. Worked with Kristy for a while. She does amazing work, and is in a lot of policy spaces and doing just all the things, I think. But she's the co-chair of the Child Abuse Subcommittee for the Utah Victim Services Commission and serves on I don't know how you see your screen not light. Okay, there we go. She serves as well on the Utah America 250 Commission and the Board of Governors of the St. George Area Chamber of Commerce, and done extensive work with nonprofits and has special passion for programs that promote the arts, enhance schools, and mentor young people. She's got some fun hobbies of including roaming the trails, which there's so many down here of southern Utah, writing free verse. I'd love to see some of your writing. And her husband, John, are the parents of 5 amazing children and grandparents of 8 grandchildren. I love that. And then we also have with us today, Ryan, who is a lead prosecutor at Washington County Attorney's Office. And he has been a prosecutor in Idaho for 30+ years, started prosecuting special victims cases in Washington County in 1998. And is the lead prosecutor at Washington County Attorney's Office since 2004, and red is his favorite color, so. I feel disappointed that you're not wearing red, but I.
Lots of it.
Coastal Carolina.
Coastal Carolina, I love it. So we are gonna turn the time over to them. I know that child torture can be a heavy topic, but it's such an important one to know the different changes and the amazing work that Washington County has been doing to make those changes, so. You can have a mic. One's on, let me turn this down.
And there is a clicker as well.
And then, yeah, the clicker, got it.
I gave it.
Is it on? I'm just making sure the mouse is over here.
So. No, yes, no.
Yes.
Right here? Okay.
Woo.
This child torture statute is a long time in coming and is one that has been desperately needed. Given what we've seen over the last, I don't know how many years here in Washington County and in the state of Utah, it became fairly apparent, or even more apparent, I guess I should say, over the Frankie Hildebrandt case that we needed to make some changes in the law, that aggravated child abuse was not going to be enough to deal with the most serious child abuse and psychological abuse cases that we had. So there has been efforts made, particularly this last year, to take the legislature involved. Don Ibsen, Senator Ibsen was gracious enough to be willing to sponsor the bill, and Kristy and the former Washington County Attorney Eric Clark spent a lot of time with the legislature and with those who were trying to help craft this particular bill and the end result that we have here today. We believe that that this is a good, I wouldn't say first step. It's a good bill, but we know that, you know, in the future it's likely to have some tweaks and changes, but we're addressing some of the more serious and fortunately some of the crimes that don't happen quite. You hold your mic a little closer. A little bit closer? Oh, okay, now I can hear myself.
Yeah.
Okay, thank you.
So before we go any further, I know we have a lot of people who see really hard and heavy things every day in the course of your work. And I will say that just in talking about examples and the things going on behind the scenes as we developed this law, this is your trauma-informed warning that we're gonna talk about some really hard and heavy things. And if you need to step out or do whatever you need to do to be well, feel free to do that. We will not show any pictures. There are no graphic pictures, but we will be talking about some really hard things. So, let's talk first about a little bit about some of the history. So, about 9 years ago, there was a case here in Washington County, the Jane case, of a child who was locked in a bathroom of his home for years, sometimes walled into a shower. Mom watched abuse from a baby monitor remotely on her computer. There was a twin who was residing in the room next door who had there was no torture going on there. But this kiddo, when he finally was found, was 12 years old and weighed 30 pounds. So that it was kind of like one of our first big holy goodness. We got to do something different. And as part of our CJC symposium last year in 2024, there was a case review of that case. And a number of us were just so horrified by, and we did show a picture, I didn't do it, but some pictures were shown. It was really, really hard. And so someone came up to me and said, why can't we do better than this? In the meantime, the Frankie Hildebrand case was happening in Ivans down here. I promise we don't do all of the torture in the state here in Washington County. It just feels like it sometimes. And that case, you know, getting the national and even international attention that it did, brought to the forefront that the worst charges for physical abuse of a child were second-degree felonies. That's aggravated.
That's aggravated child.
Aggravated child abuse. And it wasn't enough. It did not begin to represent the harm that happened in those cases. And so, and then there were other cases across the state as well. Gavin Peterson was front and center of in northern Utah. This bill obviously wouldn't have helped him because he died. So if a child dies, then you've got something. But if they live, then it just wasn't sufficient. But torture a child was kind of forefront on the minds of people in the state and legislators as well. And it gave us an opportunity to do what we knew needed to happen, that we hadn't really had that window before. So what the bill did was create a first-degree felony for torture of a child, with a 10-year minimum mandatory sentence that could be stepped down to 7 or 4 years, if the reasons are documented by the judge. And it also we had to add a narrow definition of psychological injury for child abuse. And we're going to go into just the actual details of the law and explain it. And we're going to start, I think, with talking about psychological injury.
Just so you have a frame of reference on what changed, with the first degree felony, you see the 4, 7, starting at 10 and possibly 7 to 4 years, depending on what the judge knows with the case. Second degree felonies is a 1 to 15 year sentence, non-mandatory prison. Oftentimes, perpetrators were getting off with a little bit of jail time and probation. So we are fortunate in the Frankie Hildebrand case to get 4 convictions on 4 counts for each one of the perpetrators. But even then, their sentence was 1 to 15 consecutive, and in those cases, we don't expect them to serve any more than possibly 4 or 5 years at the most. So thank you. So Next slide, psychological injury, okay. So many of these cases that we have involve psychological injury, and if you think about it, what torture case doesn't involve psychological injury? The problem with trying to figure out what psychological injury to the extent of torture was very challenging. It was hard to figure out what other states were doing with it. It was all over the place. There was no torture statute like the one we were trying to create to look at and apply to the state of Utah. We had the challenge of legislators who were concerned that psychological injury left it wide open and that people could be charged even if they weren't physically harming a child with doing things that were maybe strong parenting. And we're concerned as to how that was going to be defined. One of the things that helped in this case is that we put in the statute that there needs to be an identifiable mental or emotional harm, damage, impairment, or dysfunction. Identifiable meaning either it's going to be obvious on its face, or we have to have a expert come in and describe the type of injury and the severity of the injury that the child has. It's not just anything. And that helped get this legislation through the legislature.
And one of the reasons we had to include that psychological piece was because in some of these cases, for instance, waterboarding, and there has been a case of waterboarding of a child here in the state of Utah, not in Washington County, but there's no mark. There's no actual physical harm, but I don't think anyone would argue that that's not torture. So we had to figure out how to get the psychological piece in there. And there was a time when we have 6, 7, 8 attorneys working on this from different prosecutors' offices across the state, attorneys from the AG's office. And there was a time when they got together, and I'd been kind of doing the research piece on what was going on with torture laws across the state, not across the state, across the country. What could we model our law on? And the answer was there wasn't much out there. There really wasn't much to model anything on. And so there was a time when all the attorneys got together and they were like, you know, it would be so much easier if we did not have to define torture. If we could just have an enhancement on the aggravated child abuse statute. And fortunately, that's not what happened. Because this isn't just, we're not just talking about aggravated child abuse here. Torture is something entirely different. And unfortunately, as a Supreme Court justice famously noted, talking about pornography, I can't define it, but I know it when I see it. And you can kind of see how that sort of thinking applies to torture as well, but we really felt like, and I'm gonna cop to it, I really felt like we needed to define torture, and I wasn't alone, obviously, and Dr. Toni Lasky, some of you may know her, she's one of the foremost child abuse pediatricians in the country, testified to the bill at a legislative interim hearing almost exactly a year ago. And I was just gonna read a little piece of her testimony to explain why we felt like torture, we really had to get to torture and not just an enhancement on aggravated child abuse. And so this is what Dr. Lasky said. Over the last few years, my 2 child abuse pediatric colleagues at Primary Children's and I have been involved in the evaluation of at least 12 cases of severe torture from around the Intermountain West. This is a medical diagnosis that entails severe, repetitive physical abuse as well as psychological abuse. These cases involve confinement, sometimes with ropes or handcuffs, sometimes to closets or crawl spaces. They often involve the restriction of access to a toilet, requiring the child to wear a diaper or use a bucket they are given. It frequently involves malnutrition, either through severe food restriction or giving the child inedible food, such as dog food. It may include beating with implements, burning, electrocuting, strangling. This is not unique to Utah. It is happening nationally. My colleagues around the country have been talking about this issue because of the recent inexplicable increase with such remarkable similarities that you can literally take the histories and just change the jurisdiction because they are so similar. We don't understand why this is happening, but what we can all see is the inadequacies in the tools we have to deal with these cases in our states. Until very recently, most states did not have legislation that allowed criminal charges that address the depravity of these cases. If the child dies, there are often charges that can apply due to the death of the abuse, but if the child lives, there is nothing that adequately addresses what has happened to these children. Broken bones heal, burns heal, bruises heal. Survivors of child torture will have decades, if not their whole life, to work through what has happened with them. Many are not able to do this successfully. The cost of survival for the victim, as well as the other children in the care environment, is incalculable. This isn't just severe physical abuse. This is something that we literally have a Geneva Convention to protect our military from. And it's happening here in Utah to our children. And so we really felt like it was incumbent upon us to figure out how to define torture. And so this is what we came up with. And you look at that and you go, man, that's 3 little paragraphs. That's easy schmeezy. Oh, man. It was not. It was really hard. And the actual bill had 80, 90, 100 more pages because of all the different places that it affects the statutes and codes. So, child torture. An actor, why did this one you doing it?
That's yours.
Okay, so I'm just gonna keep talking. Okay, so an actor commits child torture if the actor intentionally or knowingly, that's important, we'll talk about that, inflicts upon a child or having the care or custody of a child, intentionally or knowingly causes or permits another to inflict upon the child, and then we've got 2 ways of getting there. 1, a serious injury that is inflicted in an exceptionally cruel or exceptionally depraved manner, that's important, that causes the child to experience extreme physical or psychological pain or anguish, or a serious injury or more than one serious injury as part of a course of action or conduct, a course of conduct over a prolonged period of time. So there are 2 ways of getting to torture, but it's required to be intentionally or knowingly and exceptionally cruel or exceptionally depraved. So
Just
There you
to distinguish that statute from aggravated child abuse or child abuse for that matter. Those crimes, can go all the way down to criminal negligence. Torture cannot. And it kind of makes sense. If we're talking about something that is exceptionally cruel or exceptionally depraved, it's kind of hard to think how somebody could be acting with just criminal negligence or recklessness for that matter. It has to be a knowing and intentional act. The first part of the statute, the first element of the offense is that they are inflicting a serious injury upon the child. So this is the definition from the Utah Code of what serious injury means. And it distinguishes injury to a child, to serious injury to a child, to torture. So what kind of injuries are we talking about when we're talking about serious injury? Anything that impairs the child's health, seriously impairs the child's health. And we have the inclusions there, fractures of the bone, intracranial bleeding, swelling, or contusion of the brain. I think those first 2 are speaking directly to what we see in shaken baby syndrome, in children who have been shaken and impacted against the hard surface. Those are obviously very serious injuries. And many of those will, of course, rise to the level of aggravated child abuse. But they can also be elements of torture. Burns, any kind of burn, it could be a water burn, somebody puts a child in a scalding, a hot bath of water. It could be any other kind of burn from a flame, pressing something hot against the child. Dangerous weapons being used against the child, obviously. 2 or more injuries under 5, any combination of 2 or more injuries inflicted by the same individual. In other words, 2 non-serious injuries can amount to serious injury if there's more than 1. Now, that is true for aggravated child abuse if there are multiple injuries. But there is a caveat to that in this particular torture statute. That alone cannot rise to torture. In other words, you can't have a bruise here, a contusion there, and voila, we have torture. There has to be more than that. So that's the only caveat to this serious injury definition in its application to torture. But if you notice below 5 there, then we have damage to organs, and then we have the emotional harm and severe developmental delay and intellectual disability and impairment of the child's ability to function. Those are things that we commonly see in torture situations, particularly in the Jane's case and in the Hildebrand Frankie case. Permanent disfigurement, et cetera, and I don't need to go through all of those, but there are a lot of things that apply. Yes.
Said under 5, or if there's any combination of 2 or more injuries inflicted by the same individual, that there needs to be additional harm or additional. What do you mean by?
There needs to be more than just an injury, a minor injury, something that is not serious injury. Anyway, let's say that you had minor injuries, but you had significant psychological injuries, then you're okay. But you cannot have simply, what's that?
So 5 does not stand alone.
5 does not stand alone, for the purpose of the torture statute.
This part of it was super confusing to me as we were in the middle of writing it, and so I'm not an attorney. Thank heavens. I won't be right. So you can get to serious injury by having more than one not serious injury, right? Right?
In addition to.
So-
2, not
Yeah.
serious.
So if one of your serious injuries actually came from multiple not serious injuries, bruises, not such a big deal injuries. I hate to say that when we're talking about children, but then that serious injury, you can't do that twice and call it torture. It has to be an actual one of the other serious injuries. Does that make sense now?
Right. So let's say you have 5, you have 1 injury that doesn't qualify as a serious injury, yet you have a,
5 says that you have 2 or more injuries.
yes, right.
So if you have more injuries, are you good, or you need
No.
additional?
No, it
They
can't
have to be serious.
It has to be a serious injury. So let's say you have one injury, a contusion. But down here you have a child who has been, that has been confined in any manner for a significant period of time. That 1 injury is enough in combination with the other serious injuries. You know what I mean?
But 5 says you need 2.
5 says
More
you,
injuries
yes.
inflicted, so
Yes.
you have a contusion, and then you could have
You,
psychological.
if you have a smaller injury and a serious injury, you're there.
That's-
You know what I mean? The point was, the concern was, we don't want to say that a bruise here on the arm and the bruise on the leg, in and of itself can amount to torture. There has to be more than that. So.
It's confusing. I
Well,
don't-
Is
Yeah.
there like a little parentheses that says in
Yeah.
addition to
Yeah.
this threshold or must meet this, criteria to agree?
No, there is a specific.
There is a cap.
Provision in the torture statute.
Yeah.
That addresses.
There is. Okay, so that was absolutely the most confusing element of the law. I'm gonna totally say that right here. Okay, so let's talk about exception. This is the other piece you gotta have. It has to be exceptionally cruel or exceptionally depraved. That language isn't language that we made up. We borrowed it from the aggravated murder statute, so there's already case law around what that means. And it does describe extreme physical or psychological suffering. And it's it's one of the ways we set apart torture from just aggravated child abuse. Does that make sense? You gotta have that exceptionally cruel or exceptionally depraved. And it also has to have been intentional. It can't have been negligent or what's your other word?
Reckless.
Reckless. It has to have been intentionally inflicted.
Okay. I would just point out that those adjectives exceptionally, do indeed distinguish torture from aggravated child abuse, because they are the exception. Aggravated child abuse is certainly horrible. But then you know, when you see it, you look at some cases and say, this is over the top, this is crazy stuff.
And by the way, we don't expect this law to be used a lot. We're not expecting that you're gonna see this even every year. We hope not, but it's there for those exceptionally cruel and exceptionally depraved cases if it's needed.
So the second way, the or, that you can show torture is, that course of conduct over a prolonged, or over a prolonged period of time. That course of conduct can look different depending on who the child is, what their abilities or disabilities are, and one of those disabilities would be age. A child who is 6 months old can be more susceptible to certain types of child abuse than perhaps a teenager would. So a prolonged period, for example, of isolation and lack of nutrition, lack of food, is going to affect a 6-month-old a little more than obviously a child who is in his teens.
We actually looked at trying to put a time frame on this. And then there's no way to put a time frame on it that's specific in terms of months or weeks or whatever. You know, you cannot feed a 17-year-old for a day and they're gonna be okay, but if you don't feed a 2-week-old for a day, they're gonna be in trouble. So just because of as Ryan explained, the differences in what kids can endure at different ages, we opted to leave that time frame open.
Torture just looks different depending on who the child is and what that looks like for them, so.
And we had to include it because of things like starvation and confinement.
Course of conduct also, or over a prolonged period of time, can be a continuous act. Let's say you're starving your child. Well, that goes on every second, every minute, every hour of the day, if you're not feeding the child. Sometimes that torture looks like I committed a serious abuse act here. An hour or two later, I committed another one. Maybe they're days apart, but it could still be torture. Again, each one of these, we have to look at individually and determine, do we have a course of conduct? Is it over a prolonged period of time, and the prolonged part is child dependent, so.
So, I borrowed this word sentinel from our medical team who, talks about sentinel injuries for kids. Which are just things that should make you go, they aren't things you should normally see. So these elements may not necessarily get you to torture, but they are things that if you see in a case, you should be thinking, is this torture? You should be asking the question. So use of restraints, as we said, it could be handcuffs, it could be binding, or isolation, solitary confinement, forcible stress positions, starvation or unreasonable restriction of fluids, withholding food as a form of punishment, unreasonable subjection to exposure to excessive heat or excessive cold. We saw that in the Hildebrand case, Frankie Hildebrand case, sleep deprivation, waterboarding, restriction of the use of toilet, as Dr. Lasky talked about in her testimony, and anything that dehumanizes the child. All those would be things that if you see them in a case, you should be looking for, do we have the elements of torture? And there are other things as well, but these were just a few of the things that we see frequently as we look at these cases.
Just a few examples of red flags that can suggest possibly an incident of aggravated child abuse or torture might be going on in that household. Some of them are, you have a child or children who have had visits from DCFS, Child Protective Services. Next thing you know, they're all pulled out of school. There could be a variety of reasons for that, but certainly one of them is to not have the public and certainly the school system and DCFS watching to see what they do to parent their children. So that's just something that perhaps, you know, is one of those things that we should be watching for, and making sure that these children are not subjected to that kind of abuse. Yes.
And can I just, to be clear, there are some amazing homeschooling parents. I was a homeschooling parent. I don't think I was amazing. It was hard. Homeschooling is hard work and you know, if parents want to homeschool, that is awesome. But what we are seeing is in almost all of these cases, in the James case, in the Frankie Hildebrand case, in the Gavin Peterson case, as soon as DCFS gets involved, the parents pull the kids out of school. It happens almost without exception. So it's just something to a red flag maybe to check on.
And as is apparent in many of these cases, in the two main cases we've been talking about here, James, Frankie and Hildebrand, you have some siblings who are in school, in activities, doing things public that other children are not. In James, that little boy never got out of that bathroom. His sister was out, other family members were out in public, he was not. So if we're seeing family members who are out and about, doing various sports activities, what have you, and nobody knows where that one child is, maybe that's a red flag that something is amiss and perhaps needs to be further investigated. So kids often will come to school who have not been fed, looking for food and will steal lunch boxes and steal whatever they can to eat because frankly they're hungry. So that could be a sign, could be something else. Again, these red flags don't mean definitely we have child abuse going on, but that's concern.
They just mean look some more.
Yeah.
We all as victim advocates deal with families who have food insecurity all the time. So again, the fact that a child's hungry at school does not mean that they're being tortured, but it is an element that we often see in torture cases. Is that it?
I think so.
Okay, so we are open to any questions if you have any. Yeah.
Yes, oh yeah. Sorry, we need it for our owl people. I just wonder, like, is there any reasoning as to, like, the one child is excluded?
You know, my experience as a prosecutor, sometimes a child, at a young age has, for some reason or another, frustrated the parents. And they believe this child needs to be punished for something that has happened, and it grows from there and has legs of its own, and next thing you know, this child can't do anything right. And the others are okay. That's a common theme. Again, we turn back to Frankie Hildebrandt, you know, those two youngest children, you know, they were accused of all kinds of abuse themselves by their mother and her friend. I don't know, I don't know what they're calling it. She certainly wasn't a
Therapist?
anyway,
Yeah.
right. But yeah, they you know, focus on one child. Maybe it's, if we're super mean to this one, we can handle it, the rest of them. I don't know.
It's the classic scapegoat.
Yeah.
Often, and it isn't always that way. Sometimes the children will be uniformly tortured. We see those cases as well, but it's just this really odd phenomenon, and I don't know how you get into the head of somebody like that. I mean, how do they torture kids? I don't know. How do they choose one out over the other out? I don't know.
I'm sorry, we did have a comment in the chat from Kimberly Chappelle. Our police department saw a significant decrease in DCFS cases during the few months that COVID kept kids from the school. The minutes they were back in, increase was up to 65 to 70%.
Yeah, we did. We saw that. I think that was a national phenomenon where there was a decrease in cases during the early months of COVID, and then once kids were back in school and there were eyes on, there was an increase, and we haven't seen the end of I don't think we've seen the end of it yet. I think it probably peaked in 2022, from what my dad is telling me, but we were just looking at that data this week.
Well, it correlates to what we generally see every year in a variety of child abuse cases, sexual abuse, physical abuse. Kids are out during the summer, they're spending more time at home with family. They're not at school, they're not talking to their teacher or counselors or their friends as much, except for their immediate group that they're around. And we generally see the number of cases of child abuse go up, the number of investigations either from DCFS or from law enforcement. So
When school's back in session, yeah.
when school's back in session.
What they were seeing, and this is more of a national phenomenon, although we saw it here as well. During COVID, we weren't seeing the I don't know, I'm not gonna say garden variety child abuse, but you know, we weren't seeing our normal cases. But what we were seeing were severe physical abuse cases, often with head trauma. It was a lot of severe head trauma that we were seeing right March, April, May, June of 2020, so. We gotta hand you a mic, sorry.
You guys might not know the answer to this, but after, you know, typically we have these high profile cases, sometimes changes are made in the way that DCFS handles cases, but I think a big concern, especially from an advocate perspective, is that homeschooling, where the kids are pulled out of school, that's DCFS involvement, and then we lose track of them, and no one knows what's happening to this kid, or they leave the state. And so then there's no tracking, no one, they're not required to report to school where they might have some sort of intervention. They're likely not involved in the community or in church, so there's no one that's able to intervene or see what is actually taking place. And so I think that's always been a concerning point as well. Where's the tracking of DCFS and then them pulling them out of school, or they leave to just go to another state, where normally if we had an offender,
they, be tracked if they tried to flee, we'd have a warrant, at least something.
There's an ongoing dynamic that's been going on for years. The legislature is trying to balance, family rights, parental rights, to parent their children and not have the state interfering in that versus protecting children. And, I don't know where we are on that pendulum at this point in time.
I do.
Here you go, you can tell.
Yeah, we are a parent rights state, and we'll talk more about children's rights, later this afternoon. But yeah, when you pit children's rights against parents' rights, parent rights are gonna win right now, especially in the current, political climate every time, so. All right. I think we're done. Thank you.
Please do it.
We'll do a 5-minute break between our presentations as we get our next presenter set up here.
Thank you.